Well, if Lindsey Halligan, Donald Trump's hand-picked prosecutor for James Comey, was left, as courtroom observers mentioned, rocking and reeling in her chair and not saying a word during the arraignment, get ready, strap in, because new reporting is that the lawyer who's defending James Comey, former U.S. attorney from Chicago, a fighter, a boxer, is going to throw a roundhouse punch at Lindsey Halligan and challenge her appointment, along with some other motions that are going to be filed against the indictment. Is she going to be found to be unconstitutionally and invalidly and illegally appointed as a U.S. attorney? Well, we're going to find out, because Pat Fitzgerald, the lawyer for James Comey, is going to be filing just that type of motion. And I understand where he's getting it from. There was a very recent conservative Republican constitutional scholar named Ed Whelan, who in the National Review wrote an entire piece in which he found a memo from 1986 written by now Supreme Court Justice Sam Alito. But then when he was with the Office of Legal Counsel, that effectively says, Halligan, you were improperly appointed. If she gets Halligan kicked, there goes the indictment. And because of the statute of limitations issue, you got to bring these charges within 5 years. 5 years of what? I think he's got a statute of limitations defense. I think he's got a vindictive prosecution defense. I think he's got a selective prosecution defense. And he's got an attack on Lindsey Halligan to get her kicked out as U.S. attorney. I'll cover it all right here on the MeidasTouch Network and on Legal AF. I was in court today, so I figured I would put on my court hat and talk about what is going to happen next. It's going to go quick, folks. Rocket docket, Eastern District of Virginia, and more to the point, you also have a judge, Judge Nachmanoff, who's going to put the prosecution's feet to the fire. He saw people he had never seen before in front of him on the bench. Where are the Eastern District of Virginia career prosecutors, Ms. Halligan? I mean, he didn't say it, but the arched eyebrow said it all for the judge. Who are these North Carolina lawyers from your other offices that aren't sworn in here to be in the Eastern District of Virginia and all of that? But here's the motion practice. Let's first start on what is going to be, because it was announced in court by Pat Fitzgerald, a motion to disqualify Halligan as improperly appointed. Where does that come from? Ed Whelan wrote in the National Review, properly so, that there's only two paths to fill a vacancy at the U.S. attorney level. One of them is under Title 28, Section 546. Remember that number, 546? And the other is under the Vacancy Reform Act. We'll call it the Vacancy Reform Act. It's Section 3345. It's the only two ways you can go up the mountain. If it's under Title 28, Section 546, then the person that's put in that position is considered the interim U.S. attorney. Sometimes they can refer to themselves as the U.S. attorney. It's for a period of 120 days. Once that 120 days is over, that's it. The judges of the Eastern District of Virginia, in this case, pick the next U.S. attorney. And how do I know that Lindsey Halligan was picked that way? Because she's referred to as the U.S. attorney for the Eastern District of Virginia. Alina Habba, who was chosen under the Vacancy Reform Act method, is referred to as the acting U.S. attorney. So they know what the titles mean, you know. And under the Vacancy Filling Act, the VRA, the first assistant is then elevated to the acting U.S. attorney. That's how they sort of got Habba in, although that was a complete mess itself. Let's focus, though, on Halligan. Halligan doesn't come in that way. She's not made the first assistant and up to the U.S. attorney for the Eastern District. She's brought in what we think is under 546, but there's a problem, as Ed Whelan pointed out. You only get one 546 pick if you are Pam Bondi, and she already picked Eric Seibert, the conservative Republican who they ended up firing because he wouldn't bring the indictment against Comey and against Letitia James and others. So she already got her 546 pick, and there isn't another one. Meaning, if that's how Halligan got selected, which appears that it was, because she was never made the first assistant, then they're out of luck. because you only get one 546 appointment. How do I know that? Because Sam Alito, I have it right here. Sam Alito wrote a memo when he was in the Office of Legal Counsel in the Reagan administration. And I'm going to post it up on Substack. And what it says is the following. This is his analysis. He's now on the Supreme Court. The statutory plan for Section 546 discloses a congressional purpose that after the expiration of the 120-day period, further appointments are to be made by the court rather than by the Attorney General. It would appear that Congress intended to confer on the Attorney General only the power to make one interim appointment. A subsequent interim appointment would have to be made by the district court. This is a guy who believes in executive power, but he said even here, Congress is allowed to determine who's going to be the U.S. attorney. Now, there's going to be a whole fight about whether this impinges and infringes on the Article 2 powers of the president. Why should Congress be able to tell me who I can appoint as a U.S. attorney? But there are these two statutes that have been on the books for a long, long time. So as Patrick Fitzgerald uses them to argue that Lindsey Halligan is improperly appointed, Lindsey Halligan and the Department of Justice are going to argue that these are improper attacks on the unilateral power of the president to appoint prosecutors. So watch for that battle.
Hey everybody, Ben Meiselas here from the MeidasTouch Network. I wanted to let you know about my podcast partner, Michael Popok's new law firm. It's called the Popok Firm. Michael Popok's pursuing his dream of starting his own law firm, really based on the popular demand by all the Meidas Mighty and legal AFers who are approaching Michael Popok with their cases and saying, can you help us? And at that time, Popok was not able to. So he went out on his own. He started the Popok Firm, where he is now handling catastrophic injury cases like car accident cases, trucking cases, malpractice cases, big negligence cases, wrongful death cases. So if you or someone you know have a case like this, the consultation with Popok's firm is free. Give him a call, see if you have a case. It's thepopokfirm.com, thepopokfirm.com, or you can call 877-POPOK-AF, P-O-P-O-K-A-F. So 1-877-POPOK-AF. Give Michael Popok a call. And I'm really proud of you, Popok. Thanks for all the hard work you're putting in.
Then you've got the motion for what's called abuse of prosecutorial power. It's vindictive prosecution and selective prosecution. They sound alike, but they're slightly different. Vindictive prosecution is that through bad faith and in retaliation for some exercise of some right, prosecutors have brought the case. Now, Comey has been saying a lot of things since he left office, and he's written a lot of books. So the argument goes that he's been expressing his First Amendment rights. Donald Trump, to chill that, to punish him, has ordered the prosecution, the very nature of vindictive prosecution. You couple that with all the statements and comments made by Pam Bondi and by Kash Patel and by Trump, and the record is terrible for the Trump administration and very supportive of a vindictive prosecution case. We have a similar matter going on right now in the Eastern District of Tennessee, where Armando Abrego Garcia's lawyers are very successfully arguing that vindictive prosecution should lead to the dismissal of the criminal charges against their client by the Trump administration. And it really comes down to actual vindictiveness, sometimes difficult to prove, but maybe not in this case, and presumption of vindictiveness, which shifts the burden back to the government. Either way, we're going to be seeing a vindictive prosecution motion under the Fifth Amendment due process. Similarly, selective prosecution is really under equal protection, which is under the 14th Amendment of the Constitution, and that one he has to prove that no one in the Eastern District of Virginia has ever been prosecuted for this type of perjury, the perjury being, and just to bring us up to speed, that Senator Cruz in 2020 asked Comey if he stood by his testimony in 2017 about a 2016 leak that he says he was not a part of, yes or no. He said, yes, I stand by my earlier testimony. That's it. Very hard to get perjury on that in any circumstance, let alone the statute of limitations problems, because they had to bring the charge within 5 years. The only 5 years was 5 years from the September 2020 question. But it involved a 2017 prior testimony, which was outside the statute of limitations, which was about a 2016 leak to the Washington Post that was way outside the statute of limitations. So I think they've got a very good argument on statute of limitations. Certainly they will try. But on selective prosecution, they'll have to show that no one in the Eastern District of Virginia has ever been prosecuted under similar circumstances on a similar perjury charge. And they've got help there because there's already reporting, leaks coming out of the Eastern District, of course, from inside the Department of Justice, in which there's a memo that point blank says that the case for perjury is terrible and they can't make it. That the lead witness, Professor Richmond from Columbia, who was an advisor, policy advisor, and friend of Comey, what he will testify to presents an insurmountable hurdle to the prosecution. So you put all that together, I think you got the selective prosecution. I think you got the vindictive prosecution, whether actual or presumptive. You got the burden shifting back to the government to prove that it's not. And who's going to prove it? Lindsey, I've been a federal prosecutor for 8 minutes. Halligan? She couldn't even open her mouth during the hearing. I just did a hot take about this. Lindsey Halligan literally was rocking back and forth in court, nodding, and rocking, obviously trying to get into a fetal position as she was being completely outmatched and outclassed by two former real U.S. attorneys, James Comey, U.S. Attorney for the Southern District of New York, a once proud office of the Department of Justice and former FBI Director, and Pat Fitzgerald, the fighting Fitzgerald, who's known for hard-nosed prosecutions and defense. And a little bit of a disclaimer, I guess. Pat Fitzgerald and I worked in the same law firm, but at different times and in different offices. He worked in Skadden Arps White Collar Group in Chicago. I worked at Skadden Arps White Collar Group in New York back in another whole nother life ago. But I was wearing suits then too. So I really appreciate you all being here on the MeidasTouch Network and on Legal AF. Take a minute, hit the free subscribe button, come over to Legal AF, the YouTube channel, do the exact same thing. And of course, Legal AF Substack, where I'm posting again the Sam Alito memo, which will be a part of the attack on Lindsey Halligan to get her dismissed and disqualified as a U.S. attorney. Till my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.